What is up, guys? Welcome back to True the Transparency. It's closer. It's been wild over here. Let's turn on up so we can hear. Come on in, man. Let's see. All right, we are going to be replaying and taking a look again at the hearing. I am going to speed it up. So if you guys are wondering why people are talking so fast, y'all, we just had 100 totality of the eclipse. It was incredible. Yes, we got pictures and videos as well. So we're all still alive here. So those of you guys that stocked up with all this crazy stuff, sorry about your luck. G's finally questioning university. Wish they'd question LE and the PCA the same way. We're going to get into all of that tonight. So we're going to be talking about the interview that the parents of Kaylee Gonzalez did yesterday. We're going to talk about that tonight. But before we did that, I really want to take another look at the hearing. So it's going to be just a little bit quicker here. I'm going to go ahead and do this. Okay, here we go. Again, I'm speeding him up. So.
Questions were being asked. And Ms. Taylor represented to us, and I do not dispute this, that's why I want to make this part of the record, that she had not seen the actual questions themselves, that she had approved the topics that could be looked into during the survey. So I want to put that in the record that we are not accusing Ms. Taylor of drafting these questions verbatim and then say, go send these out to the public. We are concerned, though, that the people hired by the defense to conduct this survey did exactly that. And the examples of the things that are of concern can be found in the transcript of one of the calls. As Your Honor will recall, we had a person come to us who had received one of these calls, actually recorded the call. And so our office prepared a transcript, and that was attached as Exhibit B, I believe, to our motion for order prohibiting contact. In addition to generic questions about the criminal justice system, here's where we get to things that concern the state immensely. Question: have you read, seen, or heard if Brian Koberger was arrested at his parents' home in Pennsylvania? Question: have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question: have you read, seen, or heard that DNA found on the knife sheath was later matched to Brian Koberger? Question: have you read, seen, or heard if Brian Koberger owned the same type of car reported on video driving in the neighborhood where the killings occurred? Have you seen, read, seen, or heard if the cell phone tower data showed that Brian Koberger made several trips near the victim's home in the month before the killing? Have you read?
All right, right there. What is so wrong with these questions? Have you heard, seen, read? I see nothing wrong with these questions. Absolutely nothing wrong with these questions.
Seen or heard if the university students in Moscow and their parents lived in fear until Brian Koberger was arrested for the murders? Have you read, seen, or heard if Brian Koberger said that he was out driving alone on the night of the murders? Have you read, seen, or heard if Brian Koberger stalked one of the victims?
That is stalked one of the victims, not stopped. God, I'm taking that off.
Have you read, seen, or heard if Brian Koberger had followed one of the victims on social media? Your Honor, there is absolutely no question but that those questions are disseminating by means of communication evidence expected to be presented evidence that could be or would be inadmissible at trial. And I will say there are a number of these representations placed in the form of a question, but representations of fact that are not true or that would not be offered at trial.
They wouldn't be offered at trial. These are not true. These are offered up as fact. Where does it say that? Where did it say that in the survey? Like, what? No, they're just asking these people, have you seen, read, or heard any of this? Like, nobody says that that's fact. Nobody does that say that in the, was that disclosed to the person? Because it's not like they saw anything. They were just talking on the phone. It was a telephone interview. So did they tell them, hey, these are the facts. You want to see if you've heard any of these facts? I'm just wondering. All public info, if not true, why did you state it? Well, more importantly, they're asking people if this is what they've read, seen, or heard. Because obviously, ding, 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 the defense is over here saying that these are not known. They're statements that are in it that are not fact. And I think that we could pick the questions out that I believe aren't fact. Hence the stalking of stalking on social media, stalking.
Or the performance of results of examination tests. And these questions specifically refer to DNA testing. Now, I recognize that the defense says, well, all of this information is out there in the public media somewhere, but that misses the point. That's assuming that every person in Latah County who is called has followed all of this nonsense in social media, has followed extensive coverage.
See, right there, social media, that's not what the questionnaire was about. The questionnaire had to do with 3 publications, and it was not social media. And Bill Thompson himself says all of this nonsense that is out there. So Bill himself is calling everything that's out in the media nonsense. That's pretty wild if you think about that.
There are people who consciously avoid reading coverage or listening to coverage about this case because they don't want to. That's the fallacy of the position defense is taking here. So what the agents of the defense have done is they have gone out and interrogated 400 citizens of Latah County and embedded in them facts specific to this case, some of which are not even true, some of which would not be admissible in court. And those people, whether they had heard that information before,
they embedded them. What, excuse me? They were embedded with this. I'm sorry, but Bill is making a huge deal out of this. A huge deal is not even true. Like that embedded. They were asked how long was the conversation? How long did the survey take? I want to know how long the survey was. Like how long did it start from the time that they answered the phone to the time they hung up? Because how long did it take you to read off those questions? And how long would it take me to say yes or no? Wild, fucking wild.
are now saturated with that information. That is exactly what the non-dissemination order was intended to prohibit. That is reckless conduct, and it's outrageous. They can ask a survey, and they can ask people, what do you know about the Brian Kohberger case? What have you heard about the Brian Kohberger case? What do you think about the Brian Kohberger case? Do you have an opinion as to whether he's guilty or not guilty? Why do you think that? They can ask all those questions, legitimate survey questions, if you want to do a legitimate survey of public sentiment. But these questions go far.
Okay, if Bill Thompson is saying this is not a legitimate survey says produce the expert that you consulted with who said that this is not a legitimate survey in this type of, for this situation. If he says he says the words, if you want to have a legitimate survey, ask them what they know, how they feel, what their opinion is on the Brian Kohberger case. That's not what we're trying to figure. That's not what they're trying to figure out. But I want to know why why Bill Thompson says that this is not a legitimate survey, and that in order to have a legitimate survey, you should have been asking these questions. Where did you get that from? Who did you talk to that said these are the type of questions that would make it a legitimate survey? What they did is not a legitimate thing. Because you converse with an expert that you would have had to combat Ann's expert. But listen to Bill Thompson saying this is not legitimate. And look at Miss Jennings over here, looking away, hand covering her face. She's like, God, this is embarrassing.
Far beyond that. And I recognize that that it is represented, that the survey questioning here in Latah County with those 400 residents has been completed, but they're already saying they want to take these questions out to other possible veneers. Doing the same thing in other potential jury pools that they're doing with our own. That is far beyond acceptable.
How is that far beyond acceptable? How is that far beyond acceptable? Hello, beautiful people. Just got done eclipse watching. It's a total eclipse of the heart, guys. Come on now. You guys. I'm going to have to, like, wild.
These are questions that, quite frankly, might not be able to ask in voir dire, much less into an uncontrolled, unsupervised environment without any bounds, and just recklessly feeding this information, which is sensitive. And it's particularly sensitive when it comes to
recklessly feeding this information. Man, Bill, you are gonna eat all these words, bro.
Information the state does not believe is true, or the state does not believe would be admissible or would be offered at trial. On the issue of whether information already publicly available isn't included in your Honor's order, which it clearly is because it doesn't say otherwise, we know that there is no exception in the court's order saying if the information is already publicly known, it's okay to disseminate it again. And indeed, that would be reckless for the very reasons that I just articulated, Judge. We would then be feeding information that is potentially prejudicial or that could affect the open-mindedness of prospective jurors to people who may not have heard it before. That's completely reckless. And so, Your Honor, based on that, we think this needs to come to a stop. We think if the defense wants to continue doing survey work, which they are welcome to do, given what we've seen here, the questions need to be approved by the court before they go out. And the question certainly should not include the types of questions, fact-specific questions that have been delivered.
We get to hear and see and read those questions before they go out. And we get to hear and see and read your reaction when we respond to these and say that you can't do this. Wait, this is work. This should be considered work product. We get to see and read your work product and okay it before you do it. Wait, excuse me?
To 400 citizens of Latah County. That's where we're standing right now, Judge. Thank you.
Thank you.
So then how can we compare unless you use the same questions? That's the problem. I mean, the damage has been done.
The damage.
Well, that's one argument to make, but we don't want to perpetuate the damage that was done. And if they want to do a comparison, then they could have another survey in Latah County and do a responsible survey questionnaire instead of one tainting this people. And frankly, they should ensure
a responsible one. See that again? Like, write that word down. Now it's also that this was an irresponsible survey. On who by whose standards? Whose standards is this an irresponsible survey? Bill Thompson, you cannot argue something where you are. Where's the legal argument? There is no legal argument here. This is Bill saying that this is just irresponsible. No legal, nothing cited, no legal S, nothing. Well, I just like.
that they don't go to the same phone numbers that they preloaded with this other factual information when they make their legitimate survey inquiries. The defense's people brought this on themselves. It's not the state's fault. Nobody had control over this other than the folks working for the defense. They made their bed. They got to live with it. I mean, frankly, if we were in the commercial context, we would say, not only will you do this over and do it correctly, but we will not pay you for the work you did that was so outrageously wrong. That's not the context right here. I don't care about that. What I care about is making sure that more people aren't tainted. And I would suspect, Judge, as we move forward in this case, that the state will be asking the defense, and if they
now Bill Thompson is like saying, we are not going to pay for this.
Aren't willing to provide it, asking the court to order the defense to provide the identity of every person that was contacted in those surveys. So when we get to voir dire, we can identify people who have been contacted, I guess is the best word to describe, and faced with these questions. And so we can incorporate that into the questions during voir dire to see just how much impact, if any, it had on each one of those particular jurors. I don't know how else to deal with this. I realize
disqualified 40 people.
well, we could 400.
400, that's what I meant. Sorry. Yeah, 400.
And we can do that. You know, Lake County has what, almost 40,000 residents, although not all of those are going to be part of the jury panels, prospective jury panels, but 400 may be a reasonably small number. And yes, I think that certainly would be a viable solution, is just identify those people. We can certainly identify them by telephone number who was called, and just not include them on the list.
Bill Thompson wants these people excluded.
Since you're standing up, you wanted to talk about due process.
Actually, Mr. Nye is the one prepared to talk about due process, and that's why he's on. He's available by Zoom. If you'd like to have that now, that would be good.
I'll come back to that.
Yes, sir. Thank you.
I'm concerned about that, Ms. Taylor. So go ahead.
Here we go.
Your Honor, we have Brian Edelman ready to testify by Zoom about these surveys if the court would hear his testimony.
First, I want to hear about the process. I care more about how this came down than what he did. Although,
okay, right there. Did you hear the judge? He says, "I care more about this process than what he did." So right there, Bill, everything that you argued about for the past, I don't know, 10 minutes and 18 seconds. When the judge is going back over here to Anne or giving her first chance to talk, he's not even talking about any of that. He wants to know how this process started. He wants to hear that first.
I just learned for the first time that you had nothing to do with the questions.
He is learning for the first time. Okay, because that means that he's reading from his paper based on the filings of how Bill Thompson did this. And for the first time right here, I'm understanding now that you didn't have anything to do with these questions. Well, why were you under the impression that Ann Taylor had something to do with the actual physical questions? Where did that come from? And there's only one answer for that, and that's and that's Bill Thompson. Unless other people are communicating that to you, Judge. Unless there's other ex parte communication. So what was communicated to you, Judge, that you were under the impression that Ann Taylor wrote these questions? You know what I mean? Think about that.
I didn't write the questions, Judge. Those questions are generated by Brian Edelman, and he can tell you who he is and his educational background and why the questions are crafted as they're crafted. But I approved him doing this survey. This is not an anomaly. These kinds of surveys are done in high-profile cases quite often. I don't know how I could present to the court what's going to be required at the venue change hearing without understanding what is going on with the public. This is an anonymous survey. This is not one where anybody's identified as far as the defense wants to know this or the prosecutor wants to know this. It's a random survey, and there's a reason why there are general questions and more specific questions. And Mr. Edelman can explain that, but I'll do my best to paraphrase that.
Okay, well, I'm just curious. Did Mr. Edelman was he aware of the dissemination order?
I don't know if he was aware of that or not, but we gave him no.
Okay, wait, right there. Was he aware of this? If Ann Taylor just told you that she did not make the questions up, okay, and that she had nothing to do with how the survey was conducted, then how was there any violation of this non-dissemination order? Ann Taylor would have to give information to somebody to disseminate. Ann Taylor didn't do that. So I don't understand why Ann Taylor right there didn't say, excuse me, what do you mean? Was he not given the non-dissemination order? We didn't disseminate anything. What did we disseminate? How could we have disseminated anything? Right there. That's the argument right there. I didn't give him anything. He compiled that. That's why you need to talk to him and hear how he compiled how he compiled these questions didn't come from me talking to him. It came from him reading 269 articles. Okay.
No information in the case, Your Honor. He received nothing from us as far as.
Right there, she says it. He received nothing from us. So people out there, she says it right there. what I had wanted her to say 5 seconds earlier. She says it 5 seconds right there. So anybody out there that's questioning if Ann Taylor's good or not at her job, check, 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 check. She says it right there. I did not disseminate anything. We did not disseminate. We did not give him anything. Therefore, we did not violate any dissemination order, non-dissemination order. We didn't give him anything. Did these twits, nimrods, invalids, did you guys not read the declaration of the motherfucking man, Brian Edelman, to say exactly how he conducted? I mean, I do my homework before I go into these hearings that I'm going to go live and talk about. I dissected it the night before and I said, this is what, we can expect to see in this hearing. And that's why I think I was just completely blown away, because it was like, did you not read the declaration? In the declaration, it says exactly how this was conducted and where these questions came from. And it came from him reading 269 articles across 4 publications. That's where he comprised and came up with these questions.
There's no police reports, no contact with our client, no interviews. He received no information. His entire construct of this survey is as he does in his high profile cases. He pulled the media local to this area to see what the most common stories were. Those are things that are in the public arena. So this court and counsel knows how much coverage this case has received. And he does what he does by looking only at what's in the public.
Right there. She says exactly what I just said. So again, check, check. Ann Taylor, check, check. People out there that don't think that Ann Taylor is representing Brian Kober and that she's in on the U of I tangled weave because she's graduated from the University of Idaho. She's articulating it pretty well. We did not give him police reports. We gave him nothing. So there is no violation of the non-dissemination order. It's that simple. In order to be in violation of anything with a non-dissemination order, you have to give that information up. You have to disseminate it. Okay?
We didn't provide him any police reports. We didn't.
I'm sorry. It's just that does miss the point. I mean, it's kind of ironic that we have worked so hard, including you, okay, both sides.
Now he's like, you're missing the point. Okay. Now listen to what Judge says here, and you're going to have a really kind of understanding of what we're dealing with. And if Judge remains this judge, and then for this case, this right here on what Ann just said to him, I didn't disseminate anything. He got it from these articles. Now listen to what he takes and what he's already concocted in his head that he's going to say. This is when you're talking about a biased person, is somebody that already has their mind made up prior to even hearing what this broad's going to say.
To protect a fair trial, okay? And our concern from the very beginning was all the media stuff floating around, okay, that affects your client, Mr. Koberger, to get a fair trial. And some of these questions actually create a concern about, that they're inculpatory.
Boom. The first person to say the word inculpatory is Judge, not Bill Thompson. This is why I want to do this, this live. Okay, it was not Bill Thompson that said inculpatory first. It was Judge that said the word inculpatory. And I am fucking just, let's start taking shots right now. And we're going to get there. I'm going to start doing shots with you guys here around 5. Because what in the actual F are you talking about? How could any of those 10 questions truly inculpate somebody? Then when you find out the 10 questions that she asked only a couple of them are true in terms of like Brian was arrested in Pennsylvania, but it wasn't because he was fleeing. But if all that other shit is false and that's not even a true statement, how can false evidence, false facts inculpate you? You cannot be inculpated by fucking stuff that's not true. That's not inculpating evidence. That is false evidence that you're trying to use to inculpate me. You understand that? I'm over here just like, you guys, I can't watch. People are like, hey, Lana, go watch this, go watch it. I'm sorry, I can't watch idiots. I can't watch idiots. But how can something that's not true inculpate you, me, Brian? That's impossible. Unless you're letting the police and the media push a false narrative in it over in that jury people buy fake evidence. Like, Judge, what are you talking about? This stuff isn't true, and this is what the community thinks. But you just said that the stuff that's not true can inculpate my client. Oh my God.
It could be prejudice for his client. Okay. And that I'm just surprised that both of you didn't come together and say, you know, there are certain things that we probably shouldn't put into the public on a telephone call. It really concerns me. And that's why I did what I did that Friday. Now I'm being accused of violating a due process, which is a whole big issue for me.
Right there, which is a whole big issue for me. Which is a whole big issue for me. So Judge, he uses the word me. Because I'm getting accused of violating Brian's due process. You did violate his due process because you signed an order without hearing and having a hearing. So was this hearing for truly Brian Kohlberger, or was this hearing for Judge? Like right there, he's now commingling. He's commingling his me problem with what they're here for today, which is a survey. Okay, that Bill Thompson, with no other reason than to say that he thinks it's improper, he has no case law to back that up. He has no procedures with an expert. He just says he believes that the questions are inappropriate and that this process was wrong. And that these questions are wrong.
I can understand that would not be taken. I have to represent my client to the best of my ability. And the reason for that, Your Honor, with all due respect.
See, right here, when he was done talking, I think the argument that I would have been making is that how can something inculpate my client if it's not true? If it's not a factual and evidence, how can it inculpate you? Oh, it's because all these people believe it to be fact. That's how it would inculpate my client before he was to go to trial. So we're talking about a bias. We're talking about prejudicial. We're talking about we should not be in this area. But she goes this, like, that's what I would have been saying first, is bringing up this inculpatory. Like, how are any of those? How is this survey and the questions that comprised the survey? How does that inculpate Brian? Let them say the words, well, none of that shit's true. Okay, but then you say, and how does that inculpate Brian if it's not true? No, it doesn't inculpate Brian. you're using the wrong language there. In my opinion, you should be saying that this prejudices Brian, doesn't inculpate Brian, because you need physical evidence. It has to inculpate Brian, not false narratives.
I was shocked to see the court issue an order within hours of the state filing a motion late on a Friday without giving us a chance to be heard. And that's going to delve into our argument on due process. But since it came up and since that feels like the elephant in the room right now.
Boom. Dude, Ann Taylor, you go back and you watch this again like we are right now. Anybody that thinks that Ann Taylor is not a good lawyer and did not pivot and did not handle herself with poise, very controlling. She has to be so careful of her words. She's nailing it. She's nailing it.
I think maybe we should just go ahead and address that.
Sure.
And that was my motion.
So now he says sure to that. So now we're commingling. We're commingling Brian's due process, okay, with Bill Thompson saying that these questions are just inappropriate. But also, I don't give a fuck what Bill Thompson said in this hearing. You read your brief, read your motion. She was accused of violating the non-dissemination, or not that she hired people and that they broke and violated the non-dissemination order, but that she did it, her office. That's what that brief said. That's what that motion says. And we all read it. So for Bill Thompson to stand up here and say, Ann didn't violate it, then motherfucker, why'd you write that shit? That's exactly what you didn't say that the people that they hired then went ahead and recklessly violated. And guess what? Still, they didn't do it. No one violated anything because Ann Taylor gave out. You cannot prove that Ann Taylor gave out anything. And I don't know if maybe that's what Payne was trying to investigate. And guess what? His fruits of that investigation yielded shit. Nada. Because the expert's telling you where he got it all from these 269 articles.
And I asked you to set aside the order that you made without having a chance to hear from us, making a decision that now you're locked into. And it was
right there. He crosses his arms. He's getting defensive. Judge went from not crossing his arms to now he's crossing his arms. He's in a defensive position. He is coddling himself and holding himself.
It's a one-sided
I'm not locked into
decision.
anything.
Wait, who? He just interrupted her.
My order didn't say it was permanent. And it told you that I was going to have a hearing.
Maybe I phrased that very poorly. It's a decision that you already made.
Okay, let's go back. I got the motion at 4:30 on Friday.
Boom. He says, let's go back. The only person that he really wanted to truly talk about in this process was himself. Remember how at the beginning here, he asked her, I don't want to hear about these questions yet and how they were formed or whatever. I want to hear the process. And he didn't get what he was looking for. So now he's going to explain the process in this timeline of what happened. Okay. Which is, he's pointing at Bill.
Right. Now, it doesn't even reflect, just when it was filed, because Odyssey has a delay, right? So I get the motion at 4:30 Friday. I get a response from you at 4:45 Friday, right?
I don't know what time you received it, but I
That-
filed an
that's what I
objection the
got.
minute I could.
Because then you know that about 5 o'clock, that's when I issued that. So I had a half an hour. I read the material.
So he admits here that he received the motion at 4:30 and that Ann Taylor filed something within 15 minutes. That should tell you that what Ann Taylor pulled was a legit template from something that she has. Okay.
Materials that were attached to the motion that the state filed, and I had very little information. But it seemed like there were some real.
He said, I had very little information. Now, that's not true. That's not true. He didn't have very little information. You want to know how I know that he didn't have very little information? Because they went ahead and put in Bill Thompson's motion when he filed this, they did attachments, so much so that they did the recorded phone call as one of the attachments. And then the other person that contacted them wrote out a summary of what it entailed. And that was attached as another part of it. So it was Exhibit A and Exhibit B, plus whatever that motion is, that was filed under seal. Okay? So where there were names, the residents, the citizens of Laetall County that he used, those names were in there. And that's why he said that he filed it under seal. Well, why wouldn't you use source of information 1 and then source of information 2, and then in your attachments put their names? Or file it redacted, things of that nature. But we've never had to go ahead and they've always had their exhibits under seal. But to actually physically have that motion, okay, be under seal. But he gets it at 4:30, she responds at 4:45, and he says that he had very little time. Well, so then I guess you deal with it on Monday morning. But listen.
Legitimate concerns about the survey. And obviously, it turns out there are concerns. Legitimate concerns.
He says, this is his language right here. This is all prejudicial. That you have concerns. And obviously there are. What concerns? What law-based concerns are there versus a 70-year-old guitar-playing man saying that they're inappropriate questions and that they should be written like this? The issue is did Ann Taylor violate the non-dissemination order? That was what was in that motion. He was accusing Ann Taylor of violating the non-dissemination order. That's a concern. But then here he stands up in court, Bill Thompson, and says that, well, Ann Taylor didn't do. I don't think that Ann Taylor didn't do these questions, and she didn't know that those were going to be the questions. How could you know that on this day? But in your motion, you say the complete opposite. You didn't know that then? But you did, because you talked to Ann Taylor the day before. And there was no mention of this non-dissemination violation.
About what was done in the survey. So in the my order, I told you that I was going to set a hearing. So I don't know what your understanding is with just the process.
Boom.
Okay, but I
don't understand what you don't understand about the process. That's what he says to her. You don't think Ann Taylor knows the process? Okay, we'll see what happens here.
On Friday, send this hearing. So what are we doing today? Okay, I'm hearing you out.
You're hearing her out after you made an order.
I mean, really, that's what we're talking about. That's what the law. What is your understanding of due process?
He's asking Ann Taylor, what is her understanding of due process?
My understanding is that I should have notice and an opportunity to be heard.
And you did that.
I'm having that now, but there has been a decision made by this court almost 2 weeks ago that stopped us from completing our work. I understand that Mr. Thompson raised a concern, and his last paragraph to the court in his motion was, it seems that it may have violated the non-dissemination order.
Boom.
And so we're stopped from completing our comparative surveys right there when we're up against the deadline to get to our motion to change venue. I'm looking at, it stops me from doing the work and meeting the deadlines to argue for Brian to be in a place where he can have a fair trial. I think.
How does he not understand that?
The court should not have issued an order stopping us, but set a hearing, shorten time, set it for Monday morning. If the court wanted to set a hearing for that Monday morning, we wouldn't have lost 2 weeks worth of work if the court chooses to let us complete the work.
But that could have been.
Do you understand that there is still, like, there's been no resolve to this? There's been no resolve to this. So Ann Taylor was out those 2 weeks, and now here we are today. We're watching this as a replay because I'm about to bring the heat tonight at my 10 p.m. live. This is just a warm up. So we're still there's nothing from this.
Been more damage. I mean,
How?
this less than 2 weeks really has very, very little impact, okay, on your work.
How is he telling her what these past 2 weeks would or wouldn't be? I mean, if we have to do this, judge, for every single thing that Ann Taylor wants to do to represent Brian Kohlberger, you guys will not be having a trial for fucking years. So he wants to say that these 2 weeks, keep adding up these little 2 weeks, 2 weeks, Judge. Yeah, we'll see. You're going to be, 2 years, 2 years, 2 years.
It does have an impact, Your Honor.
You don't even have a trial set.
It does. What the fuck does having a trial date have to do with anything about this hearing? There is a date set for a huge hearing, which is change of venue. That is set. That's a date that's set with deadlines on when Ann Taylor has to have a motion written up, her briefing, and handed to Bill Thompson. And then he has his 2 week time to respond to that. And then the judge is sitting there with both of the briefings, okay? So what does there not having a date on a trial have anything to do with this? It has absolutely zero to do with it. Nothing to do with it. Because there is a hearing date that's set for this purpose, which is the change of venue. So if we're going to have a judge that's going to compare apples to oranges in a courtroom, I don't care if you're there for a misdemeanor. We have problems. This has nothing to do with there not being a trial date set.
Come on.
We have our motion to change venue. We don't have trial. You're right. We don't have trial. My understanding was that we were going to hear the venue change and the court was going to make a decision and then set trial so that we didn't send out a bunch of subpoenas and reserve this courtroom unless we're going to stay here. That was my understanding. My problem,
Okay, so do you see how well she talked about a pivot right there? That's why we don't have a trial date. You agreed with me to have this change of venue hearing first, not like the state wanted to do, which was later. So you agreed with me that this needs to happen now. Boom, we're having this. Change of venue, because why would we do all this? And she's saying, why do send out these subpoenas, do all?
Sets me back is getting my work complete to get my briefing to the state in the time, at the deadline that I was already given, and meeting that hearing date that's set for venue change. And from there, everything else flows. When are we going to set trial?
We wouldn't even be here, okay, if there was some communication between you and the state.
Okay, so then he goes back to this saying, wait a second, now we wouldn't even be here. Wait, did you not hear her argument that she just destroyed the judge in what he said? Okay? Just destroyed. She said, and then he then says, well, we wouldn't even be here if you two, talking about Bill Thompson and Ann Taylor, if you guys could communicate. Like little kids. We wouldn't even be here if you two could communicate. But listen to what he wants them to communicate about, and listen to what Ann says to this. And this is so important right here, because they did meet. They met the day before. And then Bill Thompson chose to talk to his team, file into the courts at the end of the Friday day. But he decided to put in that little last paragraph that said that Ann Taylor was violating the non-dissemination order. And when a judge would see that, it's going to put somebody in pure panic mode. But then Bill Thompson came in here into this hearing and basically said the opposite.
About the survey.
There are things I can communicate with.
Okay, right. I want to rewind that. 854. Okay, right here.
Okay, if there was some communication between you and the state about the survey.
He wanted there to be communication between Ann Taylor and the state about the survey. And Ann Taylor nails this argument.
There are things I can communicate with the state about, and there are things that I cannot communicate with the state about. How I'm preparing my case is not one of those things. It's just not one of those things. I go and see Bill and
See, did you see how he moves with that when she says that? That is the truth. Do you want Brian to have ineffective assistance of counsel and he's doing this all over again? Everybody that's out there that thinks that Brian Kohlberger is guilty right now, Ann Taylor is doing everything to make sure that this is a one-stop shop, that Brian Kohlberger is not going to be able to, she has to do her job. If Brian Kohlberger is just at ease able to file ineffective assistance of counsel, this is all happening again. So people out there that are saying whatever it is that they want to say, Ann Taylor is preserving, like, this is wild to me. You want me to communicate with Judge or with Bill Thompson and my trial strategy? Like, are you on crack?
Ashley, I go to their office every week. Oftentimes we talk, we email each other, we talk to each other, but I don't need their permission every step of the way to prepare my case. Doing these surveys is not an anomaly. This is something that's done in these high profile cases.
I don't need their permission. And she's absolutely correct.
Well, apparently, Mr. Edelman did not even see the non-dissemination order, and you apparently did not give that to him. So this is a very
Wait, what the fuck? This is Tina with What the Fuck Translation Services. What the hell are you talking about? You didn't give him the order that says that there's this non-dissemination. Okay. Well, apparently you didn't give him this. Do you see where Judge is going off with all of this stuff? That order is completely irrelevant because Ann Taylor did not give him anything. If Ann Taylor was to give him like the IGG stuff, yeah, that's why you would have to be told about a non-dissemination order, because you cannot put this out. Ann Taylor would have to give him something. That's when you bring somebody in the loop of that they would have to sign a protective order. But where does this, so when Ann Taylor is speaking just before that, how does Judge jump to this part, which is, well, you didn't even give him the order. Excuse me? Why would I give him that order?
not a usual case, number one. And you know that we've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people, without permission of the court.
Okay. This is what you call biased. Bill Thompson and Ann Taylor, they're the ones you're supposed to go in there and you're supposed to listen to what they have to say. This is his opinion here, not based on anything that's been presented. Okay, that we wanted to keep the noise away from the case, which is the media. Okay, and we've done so much to make that happen that we did not want the media, blah blah. That's why there's this gag order, right? And we've tried, and you too, Miss Sarah, we've done such a. Now you just injected this you injected this media crap to these potential jurors. What Ann Taylor did was for the purpose of this specific hearing. This specific hearing, I didn't inject anything. I'm extracting from this jury pool through a third party information that we can use at the hearing to change venue to show you what these potential jurors have read, seen, or heard. Can we possibly tell you that Brian Koberger can't get a fair trial without doing the data and the research? Go find a cure for cancer. When they tell you that, what do you think you go and do? Oh, we do what? We use this new drug on people to see if it works, don't we? And then we take the data results from those people to see if what we're doing works. So Ann Taylor has to come before you, Your Honor, and it's just for this specific thing that is about the media. This is how we plan on presenting the data that shows that, because how can we possibly meet our burden, which is showing that Latah County is biased?
Without discussion with the state, I mean, that's troublesome. And then when I'm being directly accused, okay, by you in your brief, that I violated his due process rights. Now, that's not.
He is mixed. What in the?
Not what the law says, and that's not what the facts are. And you even cited cases that say exactly what due process is in the law, right?
I understand that, and I agree that's what due process.
Now, how are we jumping back to due process here? What is going on? Like, is Ann Taylor standing up there to be reprimanded, or is Ann Taylor standing up there to argue for or against the survey? I mean, what's going on here? But they are intertwined like this, and they can't be. You can't. If we're arguing a point, that's what we're arguing right here. But I don't need to be arguing anything if I'm Ann Taylor, because Bill Thompson, I brought my expert here that's going to talk about it all. I didn't violate any non-dissemination order. If you have a problem about me talking about Brian Koberger's right to due process, that's my job. And aren't you understanding that? If you violate Brian Koberger's right to due process, do you want to do this again? Like, what aren't you getting, Judge?
Is. My issue is that the order was signed, stopping our work without a chance to be heard. It's as if the state and the court had decided we violated the non-dissemination order, and we didn't.
All I was
Boom.
doing was stalling it.
All I was doing is stalling it. Stalling what for why? What are you stalling and why? You have to be What?
Okay, for less than 2 weeks so we could have this hearing, number one. Now, if you feel like you've been prejudiced or your client has been prejudiced for less than 2 weeks, okay, in this work, I'll push it out. I'll just push out the trial. I mean, not the trial.
That's what she asked for. She asked for absent leave. Like that like all of this time we're going to put this time back on.
At the hearing. I mean, is that satisfactory?
What do you mean is that satisfactory? You just took away 2 weeks of her to work. You shouldn't have to ask her if that's satisfactory. You should be stating to Miss Taylor, I understand that you haven't been able to work anything for 2 weeks. I plan on extending this by 2 weeks due to something that I felt that needed to be halted until I could hear you. Isn't that how you would respond to that? if you were a judge and in control of something, wouldn't you say, Ms. Taylor, we set those deadlines based on the time that was needed to get all of this done. I understand if I was to take away your time by putting, hey, we're just halting this until we can all be heard in the same courtroom. Okay. Then you should have worded it differently yourself, Judge. If I took away that time and just still kept that due date of when it was, then yeah, that's fuckerage, right? So why is he asking her, would that make it okay? Like, you should just be doing that, period. It doesn't matter if answer doesn't need to say, like, yeah, that would make it. Oh, thank you so much.
Your Honor, I think that might be what we need.
Fine.
I need to figure out if we're going to be able to continue the surveys. But if we are, I expect that we will need some additional time to get them done so that I can get the work to the state to review.
Okay, well, that's a different issue. I've never said, no, you can't do a survey.
Wait, what do you mean that's a different issue? That is this issue. I mean, is this judge lacking the reasoning and logic, like cause and effect? Ann Taylor crushed this hearing. And if you don't believe me, come back and talk about it in 3 months. There's nothing weak about this. He is not making any sense. He's not making any sense. I thought the whole issue, Ann's issue is that you halted something based on what the prosecutor wrote up to scare you into thinking that this was that I was violating the non-dissemination order by spraying the community with questions that I wrote up to have some third party do and feed all this information. What? No. There's no logic in any of this. And I get it. You guys don't have an issue with the survey, but you have an issue with the questions that were produced from the survey. Then we should probably hear from the guy that made the survey and why the questions are where they are. Right? No? I mean, that's just, to me, that's just common sense.
This was a total shock to me that Friday at 4:30.
He said this was a total shock to him. A total shock. What was the total shock? That Bill Thompson accused Ann Taylor of violating the non-dissemination? What was the total shock? Because having the survey should not have been a total shock. So where's the total shock? Or is it Ann's reply when she was then, if you don't let us be heard, you're violating Brian's due process? But I don't believe that came until when she put the memorandum in, which came in then. So when he's saying that he was totally shocked on Friday, that couldn't have been from anything that Ann actually did anything, because that was just boilerplate to object to it.
I understand that. It was a shock to the
I had to
state.
stall it out, okay? Because so that we could all talk about it and figure out what is the right path.
Okay, perfect. I had to stall out so that we could all talk about it, so that I could figure out what was the right path. Boom. Exactly. That's why this hearing should have been closed to the public. This hearing should have been closed to the public, just like you've had other hearings that were closed to the public. Because if you have a problem with 400 people being asked those questions, then you would have had a problem with 1 million people hearing all of the questions and all of this. Your argument fails.
Okay, because this is a big deal. And I take it very, very seriously.
What is a big deal? Because it was about what happened on Friday, that you got the shock of your life on Friday. But what is now the big deal? And he's switching modes up here again when he's out. Now it's back to, this is a big deal about what? Violating Brian Kohlberger's right due process.
And I was surprised, okay, that this was happening behind our backs, my backs.
Wait a second. He is surprised that this was happening behind his backs. What? Everything happens behind the judge's back in terms of work product, of how you're defending your client. So what in the world is Judge talking about that he is so shocked and cannot believe that this is what is happening behind his back? Our backs, him and the prosecutor. Yes, Heather. Yes, and that is why Judge, you just took this here. I'm sorry, this hearing sealed the fate for this man to be the judge of this case, and why this is not being talked about in this way, but yet everybody wants to spin it. I don't even know which way they want to spin it. But right there, he says it. Our backs. What is being done behind it? What?
Figure out what is the right path. Okay, because this is a big deal. And I take it very, very seriously. And I was surprised, okay, that this was happening behind our backs, my backs.
Right there, our backs. And then he says, my back, my backs. But what is being done behind your back? What are you talking about? Nothing was being done behind anybody's back. Absolutely nothing. What? And that's what's like, what was being done behind your back? That's what Ann Taylor right there. And I don't know if he continues talking because you don't want to cut off a judge. I get it. I was like, what was being done behind your back?
Okay.
I understand that this probably is the first time this court has run into it. I know it was the first time that Mr. Thompson has run into it. I haven't used the survey in my own cases because I haven't had a case like Brian's case before.
Okay, so she's assuming what he means. Listen to this. She goes right into it. She believes what he's referring to is that this survey was done behind our backs. Okay. And so that's why she's answering this way. And so she's saying, Bill Thompson's never done a survey before. So then how does Bill Thompson know what is inappropriate to ask in questions of this for a survey like this?
This is an extremely high profile case. I've been involved in a lot of capital cases and I understand the standard of care in capital cases. She
understands the standard of care in capital cases. She is after all, you guys, a fucking government employee. Okay. You got the state versus the state here. You got the state money versus state money. You have basically the triangle complete. The state is paying for all of this. The judge, the prosecution, and the defense. This is like having a parent at home be the judge, jury, and everything. When you have two kids that, maybe they play this. Maybe they become wrestlers and they play. You know, they're wrestlers, and here. Then they're going to go against each other one day. But here I'm the mom to both of these kids. They're wrestling in the same weight class. One's a sophomore, one's a senior. Fuck, talk about sucking, right? But every which way you look at this, the state is paying for it all. So this is like the state versus the state. And let me tell you what the last thing you want to do when you're just using all your own fucking money is, why are you guys blowing all your own money? And if you have another trial, oh God, you know how much money this is? All because, wait, people's egos?
No, that this very kind of survey was used about 7 years ago in Kootenai County in another high profile case. I wasn't on the case, but I'm aware of it.
And that's the Renfro case. Idaho versus Renfro.
I'm aware that this very survey has been used in other jurisdictions, other counties in Idaho and other states in really high profile cases. So I understand that it was a surprise to Mr. Thompson. He told me it was. And I'm hearing the court say that's a surprise as well.
How it was done. I'm not concerned. I figured there was
how it was done. How it was done. Nobody knows how it was done. He has not heard from the expert. So when he's saying how it was done, how is he How does the judge have any opinion on how it was done when you don't know, when nobody knows how it was done because nobody yet has heard from Brian Edelman, the expert that was hired to do the survey? How does he have an opinion on it when I don't know it? I don't know what, I don't, how was it done? How was it done? How was it done? Yes, he just keeps interrupting her. And everybody out there was saying that Ann Taylor was interrupting him. I don't know what they're talking about. I don't know what they're watching, but I don't see the interruptions from Ann Taylor to Judge. I see that Judge was interrupting. So what the question for me is how does this man, the judge, have an opinion to know that something was done behind his back and that it was bad? No, that you guys didn't know that but then guys, wait till this comes up. Then they say, I knew that there was going to be a survey in this case. And literally, my fucking face says it all if you guys watched me do it live. You guys, they were arguing a certain way right here, and then they admit to saying, no, we were expecting that there'd be a survey in this case. Excuse me? Then how could you be shocked? Here, it's coming up.
There's going to be a survey at some point.
Right there.
There would have to be.
Oh my God, you guys. He says it actually right here.
I'm hearing the court say that's a surprise as well.
It's how it was done. I'm not concerned. I figured there was going to be a survey at some point. There would have to be. It was the way it was done. Okay.
Right there. It was the way that it was done. The way that it was done. How was it done? You don't know, Judge, how it was done yet. So how do you already have an opinion? Because you haven't talked to this man. Ann Taylor doesn't even know how it was done. Because Ann Taylor didn't do it. This guy did in his that's what his company. So his issue is with how it was done. Okay, so let's hear what he thinks on how it was done.
Okay, and the questions that were asked. That is the real problem.
So the questions that were asked and how it was done. What do you mean by how it was done? How else are you supposed to conduct a survey without contacting via the phone to do it? Or why? Or how do you have an opinion to say that something is, you don't even know how it was done? I don't know how it was done, so I don't know how the judge could possibly know how it was done, because in this hearing, we did not find out how it was done. So when did the judge obtain this information on how it was done? Or why does he have a belief on how it was done if the guy that did it didn't testify and he's never talked to him? He would be going solely off of Bill Thompson's motion and the 2 exhibits that were filed.
As Mr. Thompson pointed out.
So the way it was done, I know in the other Kootenai County case, permission to do the survey wasn't sought of the state, the prosecutor, or the judge.
Okay, so permission was not sought.
I can comment on that one. I know
Other cases that didn't happen, so that's the same with this case.
about that. I don't know about the other cases. So that takes us to, why did we ask the questions we asked? I don't think it's common to get permission from the state to do our work. I think that it's a surprise because it's the first time that's happened, at least when this court's been on the bench and in Mr. Thompson's tenure here. So I understand that. When I met with Bill and Ashley in their office on the 21st, I asked them not to give you the police reports that they had in the transcript without me having a chance to be heard, because I didn't want an order without us being able to talk to the court. I asked if we could maybe set up an on-the-record meeting with the court to talk about this. And that wasn't what was done. It was.
So she's trying to explain to him when he's saying, I have a problem with how this was done. What was done? I'm still not understanding this, guys. What does he believe that was done that he has such a big problem with? And that has to be answered.
Friday when this went out.
Sure. I mean, I would have been available on Friday to talk about it if that was necessary.
I would have gladly sat down. I didn't offer that next Friday. I would have come to town for it. I offered the following Thursday and Friday, knowing that I had a lot of availability both of those days. I would have come to town. I would have gladly sat down. By this point, the prosecutor knows I'm not telling him my preparation in a case, and I could have explained it. The thing I didn't want to happen is exactly what did happen. All of a sudden, there's an accusation against us and there's an order signed stopping us. I appreciate the court being willing to just push everything out 2 weeks. I think that's helpful. And I mean, if that's what the court's willing to do, that's fine. But the problem is we are stopped and then we have to respond to this. And if you think about the non-dissemination order, for sure, we wanted that non-dissemination order. We're the ones that asked for it. We're the ones that argued for it. We also know that our non-dissemination order mimics Idaho Rule of Professional Conduct 3.6. And when you look at that in the comments of that, I think it's helpful. There are things that we can say publicly, but we choose not to. Our team doesn't even so much as answer no comment to emails, to calls, to people trying to talk to us, because we just don't want to do that. It's easier to say nothing. So the construct of this survey is to ask these general questions. And then you ask specific ones because you get different answers when you ask those. It is not injecting information. They are, have you read, seen, or heard? And remember, these are anonymous and these are random. So they're not planned. Nobody's planned to be contacted. I don't know the names. I'm sure I can get phone numbers if that's what the court wants. But I don't know who the people are. Nobody's identified as the person they're being called on behalf of, even when pressed by Detective Payne, that people conducting the survey didn't know. If we go back to the
even when pressed by Detective Payne, was he one of the fucking people that were called? So right here is where it's interesting, because we're still trying to understand what Judge's issue is. You did this behind our backs. What did you do behind what did she do behind the backs of our backs? And he said, I have a problem. I have a problem with the questions and the way it was done. And so you're sitting here listening to Ann Taylor say that the person wasn't told if it was coming from the prosecution side or if it was coming from the defense, even when pressed by Payne. They didn't know.
Dissemination order, which mirrors Rule 3.6, that's to prevent lawyers involved in a case from making statements that will be widely disseminated, right? To talk to the press. And the purpose of that is because I read the police reports. I would have a little more credibility than anybody else on the street saying something about the case. Same with Bill. That's the purpose of it, so that we don't say things to the press on Dateline on 48 hours, because we've actually read police reports, we've interviewed people, and we're doing the work on the case. So when you have an anonymous survey that doesn't identify.
So here what she's doing, she's explaining the process that he clearly says that he had a problem with. Okay. The process and how this happened. But what she says is, I don't want to speak for, like, why aren't we taught? Why isn't this coming from the expert?
The person conducting the survey didn't know who was behind it as far as which party to the case. They can't answer that. So all of a sudden their questioning about what you've seen in the media doesn't come from a particular party in the case. And the purpose of it is to ferret out what if people have exposure to the case. If you look at states.
This is such a good explanation of everything. So please, if you aren't catching it, and I do have it speed up for a reason, just you can still understand it, but
attachment B, you can see on page 2 that there's questions, and I'm at lines 10 through 12 about what they know about the case from the media. This is all, again, looking at our non-dissemination order and looking at the rule, things that are in the public record, right? That everything is public in this case unless we specifically seal it. So this person says they don't know much. And then if you go to page 4, there are several things they do know, and that's the purpose of it. When somebody's given a broad question, tell me what you know about this. They're like, I don't know. I don't really know what you want, so I'm not going to say anything. And they don't give you an answer. But when you say, have you read, seen, or heard X? Well, yeah. And then it's the next question. And if the answer is no, I don't, it's next question. Nobody's saying, well, it was in the newspaper on 15 occasions. And this is particular.
She's saying after the question is asked and there's an answer, you're then going right to the next question. And if they actually recorded how it was conducted, all right, so then Judge would have heard that. And I'm sitting here telling you guys, how long could this have possibly been that they had this phone conversation where this survey was being conducted and then it was over? So nobody knew what side it was coming from, who was conducting the survey. And you ask these questions. After you get an answer, you just on to the next. There's no, oh, what do you mean you didn't hear, read, you didn't see, read, or hear this? It was in 37 articles, none of that. There was no extra tidbits. So she does a great job of explaining this all, which is the issue that Judge has, but didn't even know the process to have a problem with it. What do you have with the process? How is this problematic? It is not problematic.
Borne out when you think about the things, and the state said it, some of these things are things that are just not true. That's what the Haddon case tells me I have to show you. It's not enough that there's just a lot of media coverage, and it's a lot more harmful if it's media coverage about things that aren't true. So it's nobody's injecting any.
Wait, what is he throwing his hand up like that for? Watch this. What in the world is Judge doing right here? Watch this.
On 15 occasions.
Body language.
And this is particularly borne out when you think about the things, and the state said it, some of these things are things that are just not true. That's what the Haddon case tells me I have to show you.
Who's he winking to?
It's not enough that there's just a lot of media coverage, and it's a lot more harmful if it's media coverage about things that aren't true. So it's nobody's injecting anything into the case. A random small percentage of the population is contacted. Have you read, seen, or heard things that are lifted straight out of the media? And if the answer is yes, you move on. If the answer is no, you move on. That's what the survey was about. And you can see why, looking at pages 2 and 4 of State's Exhibit B. And I think that we should also think about what the words in the non-dissemination order mean. When you say we disseminated information, that means to make widely available. This is a one-on-one conversation with no party identified. This isn't making it widely available. When you talk about disseminating information, the definition of that is to put it out there by public means, radio, TV, social media. And that's not what was happening either. These were questions. And they were things lifted 100% from the media, 100% already in the public record. And it is a one-by-one conversation. This isn't something that's being put out there through social.
Well, it kind of is.
Well, now it is.
Wait, right there in Answer's well, now it is. It kind of is. What in the fuck is this man? Judge, first of all, I want to play poker against him because I think that we could all take his money. He can't seem, I mean, he wears his emotions on his face, sleeve, everywhere.
But
I certainly didn't expect
400
this.
people, okay, it's planting some seeds where then people are encouraged, or they think, oh, well, I didn't know that. I'm going to look more into this. I mean, again, we were trying to keep the false information that was out there in media land, that it wasn't going to affect your client.
How is, okay, now this is where shit's fucked up. We did this for the purpose of this hearing that is coming up. Okay? Period. You just said that you knew this was coming. What in the world did you think we were going to ask if you knew a survey was coming? What did you think was going to happen? We have to survey the fucking community and see if they've read, seen, or heard these things. Things that are not true. Yep, Kate, I'm doing that actually. So I don't understand why Judge is gaslighting the fuck out of Ann Taylor right here. That's what's happening here.
I agree. This is less than 1% of the population. It's one-on-one. It's not by means of public communication. To think about alleging that we violated the non-dissemination order is basically alleging that we violated our ethical rules as well. And there's parts to it.
I'm not
You can't.
accusing you of that,
He's like, I'm not accusing you of that.
especially now that I know that you.
Especially now that I know that you.
That you didn't.
I didn't write the questions, but I knew what was going to happen. I take responsibility for the choices on the case, Judge, but I just don't think this is a violation of the ethical rules or non-dissemination order. These are questions about things already in the public record.
Right there is where I think she cut him off, but he cut her off first when she was talking. Because I would have let him, like, all he wanted to pipe in and said, I don't think that you, once I found out that you didn't write the questions. And it's like, wouldn't you, okay, then that's where you'd want to hear more on it. And then why immediately aren't you saying, Bill Thompson, why would you, after knowing that she didn't write the questions, why would you be putting it in your motion that you believe that they violated the non-dissemination order? If you knew that she didn't write the questions. If she told you when she met on March 21st that she didn't write the questions. So you knew that she didn't, but you still think that they violated the non. How? Ann Taylor knows that she didn't violate no non-dissemination order. But I don't understand, this extra explaining of this is not necessary. It's, the questions came from fucking publications. And then in order to see if the jury pool is biased, we need to see what they've read, seen, or heard. And so we asked them these questions to see what they've read, seen, and heard. And these are simple yes or no. And then we can then have out of the 400 people, number one, yes, this percentage. Number no, this percentage. Question number two, yes, percentage this, no percentage that. It's like a Scantron. It's a bubble sheet. Wow, 88% of the population read, seen, or heard that Brian Kohlberger was following one of the girls on social media. And he wasn't. But 88% of the people said yes to that. And that's not true. How are we going to get that out of the minds of those people? That's what the expert was going to testify to, is to all these preconceptions of this, that, and the other that you already believe, is true because you read it from somebody that you believe is producing credible information. That's why you go and you read there. You guys come to my channel because it's credible. Okay. Otherwise you don't going to come here. Where do you go and get your information? Do you read this because they're credible, or do you read it because you like to go be lied to? So something that you're reading, hopefully you're reading it because you believe you're going to a source that you deem as credible. That is what's going to rope it all in. So when they would have read, seen, or heard it, you're believing that it's credible. Okay. So I'm curious if one of the questions on there was just that, as it should be. Do you believe these publications to be credible sources? But I'm still hung up on the whole thing of what the hell did Ann Taylor do behind your guys' backs? If you guys were expecting there to be a survey, explain that. If you were expecting a survey like Judge just said, then what was done behind his back? Everything is always done behind a judge's back until it's presented in court. They don't know what the fuck's going on. So he doesn't make any sense. Any sense.
That's in our order. That's in the rule.
let me ask you, so I mean, really, getting hit by this on late on Friday afternoon, okay? I mean, I'm not sure what a judge should do in a situation like that. Would I just say, yeah, no, keep going until we can have a hearing in 2 weeks or less than 2 weeks? Or do you just pause it down so that everybody can talk about it and figure out if there is an issue?
I would say, let me ask you a question. If Bill Thompson doesn't write that he believes that I violated the non-dissemination order, would you have filed an order? If Bill Thompson doesn't mislead the courts to think that I violated a non-dissemination order, would you have produced an order without us being heard? What you should have done differently is that I'm going to halt the work on this until we can have a meeting. Okay, all the time that was halted will be added on. But if Ann Taylor thinks that she still has to make a briefing deadline on this date, but I need to use all the information that I'm gathering from my expert and this survey, how can that be?
That's how I looked at it from where I was sitting and what the information that was provided to me.
Right there,
And
he
you
said
did
it.
respond.
The information that was the information that was provided to me. Well,
But you said you were going to submit a brief and affidavit. That's great, but it was 5 o'clock on Friday.
I know.
So
And I mean, I can't tell you how frustrating that was for me. I've had this conversation with the prosecutor the day before. I'd offered
right there. So when you want to say they're not communicating, they talked the day before.
to come and talk to the court and let the court look at all this. I knew full well if they did exactly what they did, the court would sign an order before I had a chance to say, hey, wait a minute, let's really look at all of the words in the non-dissemination order. Let me tell you why we did this. I knew exactly what would happen. I don't want to say that there's like that you should do something different. I want to be heard on these things. I don't want the court to, on a Friday night, get a flurry of things that I can't respond to and ask you to think about the bigger context. We're lawyers, words mean something.
well, did you
Also,
think I wasn't going to give you an opportunity to
You
be
did it.
heard?
no, your order said I could be heard later, but there was a decision that was made then.
Exactly. There was already a decision then. So if you're halting something then without being heard, what do you call that?
And it's hard for me to wrap my head around the court taking this as an emergency motion when the words in the state's motion telling you put a stop to it are, it seems like they might have violated this. That is a weak accusation for the court to take an emergency order position on. But I know why the court did. The court has all of this and no context for it. And it's a Friday night. And
So right there, who's the problem maker here? And none of this should have been handled publicly.
I mean, if you received this on Thursday, my guess is you would have said, we're having a hearing Friday morning. I don't care if it's by Zoom.
I told you all, both sides, you know, if you need to have a quick hearing, let me know. We can do it on Zoom. I mean, I want to move this thing along.
I
And
would
now
have
we're
been
spending
available.
all this energy, okay,
Yeah.
about this issue.
I lost a weekend of what I planned to respond to this. I thought we would probably be dealing with it on in chambers on the record meeting on the Thursday or Friday until I got the motion.
I have about 7 briefs in now.
Well, you can see we lost a lot of time.
I'm not complaining about it because I'm learning a lot.
The last thing I'm going to say on this, Judge, is that non-dissemination order contemplates that you make this statement that you reasonably know is going to go out and harm the trial. This survey was never intended to do anything but identify issues within this county to support or defeat our argument for venue change. When you hear from Brian Edelman, which I don't know if you have to now because I've said some of the things.
I'm happy to hear what he has to say if you want him to be said
You'll
to me.
you would know, and you probably know from his affidavit, sometimes he recommends against venue change.
Sure.
Because it's not there. He's done with Latah County. The results aren't compiled yet. I anticipate he'll recommend we change venue. Where we are now is we'd like to finish the other 2 counties. You don't have to do 2.
You did say that he said that Latah County is biased.
I anticipate he's going to recommend the change venue for that reason.
I'm interested from him, how he defines bias.
And
We all have some biases.
Right there. I literally cannot believe that he said that. He says we all have some bias. I want to know when he wants to define this bias that he deems is there in Latah County. But he's not talking about strawberry jam or grape jam. What do you mean? What does he? Based on the answers. Based on the answers to those questions. What do you mean? Where do you he wants to hear from? Then put his ass up there. You know what I mean? But he can't make Ann Taylor put him up there. You know what I mean? She has to decide that that's where she's going with this on her own. But that statement right there,
going to recommend the change venue for that reason.
I'm interested from him, how he defines bias.
how he defines bias. I'm interested to hear how he defines bias. You guys, I guess we should look up in the dictionary. Are there a bunch of different definitions of the word biased that I'm just unfucking aware of? He wants to hear how Brian Edelman defines biased. That's what he says right there.
Going to recommend the change venue for that reason.
I'm interested from him, how he defines bias.
And
We all have some biases.
I'm interested to hear how he defines biased. I seriously, guys, I just got dumb right there. Like, bias is a particularly influential power which sways the judgment, the inclination of the mind towards a particular object. I have no words for Judge saying he wants an expert witness to define his term of biased. I think I've heard it all. He's interested to hear what an expert witness in trial innovations definition of biased is. Wow. And then says we all have a little biased. Everyone's a little biased. Let's get his exact words there.
From him, how he defines bias.
And
We all have some biases.
We all have some biases. We all have some biases. Again, we're not talking about if you prefer jam to be grape or strawberry. So I'm biased towards grape jam because strawberry tastes better and I just love strawberries. So therefore I never order grape, so I'm biased towards grape. What? I'm just wow.
will not put words in his mouth for that one.
I will not put words in his mouth for that one. I will not define bias for him, is what she said. Like, I will not put words into his mouth.
I will either have him testify today if you want to hear it today, or we'll do it at the venue change hearing when we get there. The question, I understand the court's willing to set our deadlines out 2 more weeks for venue issues. The question remains then, what do I need to show you? What do I need to present to you so that we can do a survey, a comparative survey? The target is 2 additional counties, and I really hate that I'm in here telling you all what we need to do, but here we are. So what we need to do is survey 2 additional counties. And I mean, we don't have to, we can come in with what we have, but generally I think courts ask, where could we go? And I think that's a fair question.
So courts ask where we can go. That's why they want to do these 2 other counties
Here, because we do know the media coverage has been extensive. And so I think it's fair to understand if there's a difference. If there's not, then you're left with
Can you tell me what counties?
I mean, I can. I Do you want me to publicly disseminate that? Because this is the very definition of
Well,
public dissemination.
I don't know if that should be done, or it seems like it could have some, whether or not there's some credibility about the survey, depending on what county you are looking at. We have very different counties and different thinking throughout the state. So I don't know what Mr. Edelman has in mind, or what you have in mind.
I can tell you, Your Honor. His recommendation is that we do one of the counties in Southeast Idaho because it's a different news feed and it's not on the front page of the paper every day. So we will do a Southeastern Idaho county. That will either be Bannock or Bonneville, and I think Bonneville is slightly bigger than Bannock. The other county is Ada, and the reason for Ada is because it has a very large courthouse with a lot of good security, and that court system has handled high-profile cases in a way that's safe for everybody. The population's very large there, so even if we had to draw off a lot of jurors, we'd have the population there to do it. Additionally, Ada County makes sense when you look at the Rule 21B, the convenience because of the airport and the number of out-of-town people that will be coming in, and the ability to have hotels and restaurants where there would be people wouldn't be running to other people necessarily. So Ada makes a lot of sense for a lot of reasons to me, those reasons, the courthouse security and places to stay among them. But Dr. Edelman has told us that because of the news feed that we really need to do a Southeastern Idaho. And so the decision was to do both. And in my mind, that is because it makes sense to know if we're going to go to the time to understand this and really give the court a picture, the court might want to know those two questions.
Thank you.
Sure. I don't think I have anything left to say right now.
Okay, thank you. All right, Mr. Thompson or Mr. Nye?
I'm not sure that the due process issue is something that's issued right now.
I think I already made this decision. I mean, based on the facts and the law. I mean,
There's no due process violation here.
No.
There is nothing wrong. In fact, law contemplates the court can take emergency action to stop something and call a timeout until it affords everybody the opportunity to have their say and the court can make a final decision. That is all Your Honor did here. And I would suggest, Judge, that it would not be prudent or proper for Your Honor to change or limit your own authority on that. I think that you have to continue to reserve to yourself the ability to act quickly, to cause a timeout if you are alarmed sufficiently to justify.
Nobody realized this. When Bill Thompson stands up here, he now becomes an advocate for the judge. He is now advocating and puffing judge's chest for him. Like, what is that's why is this even being talked about right here? Why is Bill Thompson telling him, yeah, you need to take back your power. You can do this and you can do that. What?
That and to give the parties an opportunity to appear before you and sort it out. Before
I'm not going to change that. That's for sure, because the law allows me to do that.
Yes, sir.
And I know what due process means.
And I say that only in light of an email that your staff attorney sent to us the other day ago that suggested that maybe the court was not going to be entering orders without full hearings with everybody.
Oh, well, but Ms. Taylor wanted, she said, from here on out, we're going to talk about that too. Because now I understand, because I haven't seen it yet, because I didn't on my computer, that you are stipulating to sealing all of the discovery stuff. And I just stopped, okay, in terms of signing on those orders that you're sending me, because I don't want to be accused of doing the wrong thing. And there's another situation that you brought up, Ms. Taylor, about that there was a prior thing where I had done that about the IDD.
Yeah.
And the state asked to do a public order, just to say that we provided the IDG or some of the IDG to you. And that doesn't really say anything except that. But you were criticizing me for that too.
Your Honor, to be clear, it's not the content of that order. My concern is the process. My concern is it feels like from our perspective that Mr. Thompson says, hey, Judge, can you do this? And I'm getting ready to weigh in and it gets done. I didn't get a response from you.
Your Honor, that was,
out the same day. I was in the process of writing, and this was by letter, it wasn't by motion. I was in the process of writing a letter to the court, asking to be heard on some issues, and the order was signed, or the new order was generated. The content of it isn't the problem, it's the concern about the process, the concern about making sure we have a clear record of what's done, and the concern about things halting what we're doing before we.
Holy shit. You know, if you guys weren't paying attention, this is actually something that even sped up caught here, but Ann Taylor wants a clear record. Like, whether she was going to agree and whatever have you, but we need to be doing things through this process, like this backwards back ass shit, you know, quick. Oh yeah, well, we always just write a letter and he's cool with it, so then we go ahead and do this. Ann Taylor saying we can't do that. And like, I get that you guys may do that for, I don't know, arresting somebody with a DUI, but we have to do things by the book. We have to go through these, like the process of doing things. And that's what Ann Taylor was just saying in a whole. The process as in a whole. Ann Taylor doesn't have a problem with the judge. Ann Taylor has a problem with the process and how you guys handle things around here. It just seems like it's like you just heard, we're hearing. They're writing letters to each other. This is a fucking capital case.
It can be heard. And
Okay, but did you want that to be not sealed? The other part, all the IGB stuff, that's like 6 pages, 7 pages?
No, Your Honor, I don't have a problem with what the court ended up doing. I was concerned about the process, and then having this order issue on a Friday without having an opportunity to talk about it, my alarm bells go off, and I think this can't happen. I probably have the court's attention squarely on me in this issue, which I anticipated, but what I didn't want to have is, I don't want to have the prosecutor writing the court letters and the court doing something and me running around trying to catch up. I mean, the thing that happened is fine, but then we have this other thing that happened, and I don't want this habit. I understand. I'm sorry.
The survey. That's what.
Yeah, the order to stop. Yeah. So it's that there are 2 things that have happened without me being able to even weigh in. That's done when the prosecutor asks you to do something. And I don't like that. I want to have opportunities to be heard. I certainly understand the court's emergency power, but if this was an emergency, the state knew from March 8th about these surveys. The state sat down and talked to me, and I offered to see you with the state. And then their motion said, it seems like it might be a violation. So I think maybe we need to define emergency a little bit better, because I know you have those powers, and I wouldn't ask you to not use the powers that you have. I think the problem here is the way this gets presented when there were a lot of different roads, and it cuts us off. And that's what I don't want to have.
Okay, I want to solve this problem if it's possible. One of the things, I mean, because you have filed motions where you didn't ask for a hearing. There's still one, couple hanging out there. Okay, and so I don't know if I'm waiting. Okay, if you're asking for a hearing or not, or if because historically you guys have worked really well together. Okay, stipulations, but then I don't get a stipulation. I don't get a request for a hearing. So what am I supposed to do then? So what I'm starting to wonder about is maybe we should just have a hearing, okay, at least once a week. I mean, a month, maybe once a
I'm
week.
here every week.
Maybe
You can
once
do
a
it.
week. Okay,
You can do it.
like a Thursday afternoon.
That's
Okay,
the day I'm here.
and then
This is just when the hearing goes completely fucking sideways to me. Like, because then we get into this like judge, this is his new face now. He comes in and I'm going to be friends with everybody. Okay. Ann Taylor's just saying, hey, this has to be done. All this has to be done by the book. So the communication, you're going to write it. You're going to communicate through the right process, not having all this ex parte communication. Do you understand that that's what Ann Taylor was saying right here? And then he's over here like, well, you guys have done a really good job, like, working together. Meanwhile, Ann Taylor has still been racking up like first, supplemental discovery, second, third. She's on her 15th. She's still creating this record, preserving it. And then I just printed off yesterday their response to Ann Taylor's, 13th supplemental request. And then here's Bill Thompson listing off the dates on when he is satisfied certain things. Okay.
Okay, so, and then we can kind of clean out a lot of these things that are sealed or, arguments about this or that. I don't particularly want to do that, but you and the court, okay, both of you, I said you, both sides, then worked really hard, okay, to protect the goal of a fair trial. And all of a sudden, I feel like it's cracking a little bit with the work together, okay? Because if we have to have hearings on every single thing, we got a long ways to go. And it's a lot of time, it's a lot of work, it's a lot of money, and it just makes everything more difficult. So if you can come together on certain things, then it's a stipulation that we need, then it's a stipulation. If it's a hearing, it needs a hearing. I'm fine with accommodating whatever needs to happen in short notice too. Because like I said before, I just want to keep moving on this. Just so taking a long time.
Your Honor, I think the record shows that we have been able to stipulate probably to the majority of things. I don't keep count. There are some issues that we have not been able to reach an agreement on. And bringing it back to the issues that are before the court right now, I realize we have a bigger picture to talk about. But the defense makes a big deal about the state hearing that there was these surveys. There were surveys going on in our community back in around the 8th or so of March. And as the declaration that's been filed with the court shows, yes, we did. And we immediately referred that to law enforcement to investigate, find out what these surveys are about, find out who these people are that are doing the survey. If you can, get that information to us. And that process is in the works. And just days before we were able to meet with Ms. Taylor on the 21st of March, just days before, we got the reports from the police department, and we also got that recording. That frankly, the recording is the icebreaker on this. It's the game changer because it's literally what was being said, what was being asked, what was being represented in the form of a question. Ms. Jennings called, reached out to Ms. Taylor, say, do you know anything about this survey? Ms. Taylor says, yes, I'll be in town on Thursday. How we talk about it. Okay, so we sat and waited. I can tell you, I suspected that this was something that the defense had commissioned from the first we heard of it. But I didn't feel that we had enough information about the nature of the survey to determine whether it was problematic. And we said this already, and it keeps getting missed in the arguments here. We don't care about surveys. We care about these particular questions asked in this particular survey. The defense is welcome to contract with people from California or wherever, I don't care, to go and ask people, can you be fair? What have you heard about this? All of those questions that Ms. Taylor was just talking about at page 2 of the transcript, those are appropriate questions for a survey. Page 4 are not appropriate questions for a survey. Just because they're put in the form, the question doesn't change the fact that they are an affirmative representation of a fact that if the hearer, the listener, was not aware of it, now they have been tainted by it. They have been, in your Honor's words, they have been injected with that information. That is a clear violation of the non-dissemination order. To think there's a distinction between putting something out in a press release.
Okay, he's wrong. He would have to prove that Ann Taylor gave him information that was not, I'm disseminating information to you, the third party that's going to make these questions, and that from that, those questions were made. Like, Bill Thompson is wrong here. This is crazy.
And talking to a private citizen is a distinction without substance. Those are both public contacts. And I can guarantee that if I went down to the bar and had a few drinks and was talking with some people and say, hey, did you know about this about the Coburger case, and the defense found out about it, they would go ballistic. And for good reason. That should never happen. But that's exactly what's happened here.
Wait. What? Bill Thompson, so your argument is that you're comparing it that if you were to go down to the local bar and ask people if they knew about something that you're going to disclose in the Kohlberger case from your own mouth to people at a bar, that's the same thing as having a survey? The fuck is this man talking about? He is comparing monkey balls to fucking eating fucking filet, okay? Totally. Ann Taylor is not doing anything. So why would you compare it to you going down to the local bar and disseminating verbally through drinking beers with people what's going on in the Brian Kohlberger case? You're telling me that he didn't think of a good analogy before he walked into this hearing on how he was going to compare what Ann Taylor did to like, this is wild, man.
Not by Ms. Taylor. I'm not faulting Ms. Taylor for the questions themselves.
Oh my God. See, then this is where, so you want to hold the people that ran the survey in contempt of the non-dissemination? The fuck? You guys, what is he talking about? I'm not faulting Ms. Taylor. Yes, you are. You wrote it in the motion that you filed when it says that they are, listen to them.
But by the people they hired to do this. And it had to stop. Your Honor was absolutely correct. Cut it off. And let's sort this thing out. And if we lose 2 weeks, well, we can make up 2 weeks. Your decision was perfectly appropriate. For the defense to claim that there's some due process violation there is without any legal basis. The defense's objection.
They cited case law, so they do have legal basis.
Is, we don't like it, Judge. Well, there's lots of things that happen in court.
Wait a second. Where did Ann Taylor say anything like we don't like it? The Ann Taylor is raising a due process issue by the judge sending out an order without being heard by only one party and not the other party.
That I haven't liked, not in this court.
Well, probably a few.
Well, maybe with Your Honor in other cases outside. That happens. That's part of the game.
I'm not here to.
But just because somebody complains doesn't mean that it's legally wrong, and there is no due process violation here. And Mr. Knight is prepared to argue due process minutiae if that's what we want. But I don't think we need to deal with that. We are dealing with the issue of these questions in the survey. They are completely inappropriate. We have a group of at least 400 people in Lake Tahoe County who have been exposed to this in violation of the non-dissemination order. I think Your Honor is probably right. The only way we can deal with, or the best way to deal with that, would be to exclude them from any prospective jury pool. But we sure as heck don't want to say to the defense's consultants, yes, go do this in other venues as well, where if we can't pick a jury here in Lake Tahoe County, we may have to go to. Go ahead and mess with them too. That's ridiculous. I do not question the right of the defense to commission surveys, responsible, proper surveys.
Do you understand that you can say all this all you want, Bill Thompson, but it's your opinion that you think the questions are inappropriate. That's your opinion. That is your opinion. And then you yourself just read all these questions out. You exposed all these people. You just actually violated, in my opinion, this hearing violates the non-dissemination order. This is ridiculous. Bill Thompson, your opinion is that these questions are inappropriate. That your argument fails. That's who do you have to combat that? This is how we ran surveys. I've never seen a survey ran like this. These are the sample questions. The questions that they were being asked and how it was being handled, messed with X, Y, and Z. Like, that's what would be done.
As part of the debate over venue. But this survey cannot stand. If they're going to do that, then they need to start from scratch if they want to compare it to Lake Tahoe County. There is no way to take the 400 responses that have been loaded with these factual representations in the form of questions. There's no way that can fairly be compared to surveys without those questions anywhere else. It's apples and oranges. And yes, it may be an expense, and it may be a delay of time, and it may be an inconvenience, but it is not of the state's making. It is entirely the responsibility and the fault of the agents of the defense. Entirely. We don't care if there's a survey. Now, I'll keep saying that because we keep hearing from the defense that we don't do surveys in Latah County. That's not the issue. We know a survey is going to happen here. Now, when it comes to this idea of what happened 2 weeks ago, when we met with Ms. Taylor, we said, Ms. Taylor, actually I said, Ann, we gave her the information. We talked about it. She indicated she wasn't aware of the actual questions. We said, we're very concerned about this. This needs to stop. And the response, if I remember, was along the lines of, well, we think they're about done in Latah County anyway. I said, well, we need to bring this to the court's attention. Here's my proposal. We will send a letter to Judge with these attached, copy to you, and then we can have a discussion. And I was told no. The defense did not want, Your Honor, to see this without also having whatever they wanted to offer in response to it as well. I said, well,
What? Okay, so how is that not fair? You want something that's fair? Because you already just biased the damn judge. Okay. Here, we'll stop. We won't do anything. We won't contact anybody else. Let's ask the judge to have a hearing, and then you can bring your issues up, and I can bring mine. We'll stop right now. But why would I ever subject the judge to all this shit? That's what he has in front of him. He became biased because he thought Ann was violating the non-dissemination order. How come he thinks that? Because of what Bill Thompson wrote and said. That's why. And then he just finds out the day of the hearing, oh, I didn't realize that you didn't write the questions and that you didn't give him any information to ask the questions. So then you're not in, then I don't think that you violated the non-dissemination order. But how Bill Thompson thinks he's going to come up and just say that these are highly inappropriate questions, that isn't good enough. That isn't good enough. And for the judge to think that they are not appropriate, why? We're asking the people what they have read, seen, or heard. But you want us to ask questions that say, can you be fair at if you were selected as a juror? Excuse me? The hell is that? How is that going to find out anything? If you were asked to be a juror, could you be fair? Are you?
that's not how it works. I mean, we'll file a motion. Normal law practice. I've been practicing for 43 years. I lose count now. If you can't resolve something, you file a motion with the court. If there are things you want to base your motion on, you attach them to the motion, and we proceed from there. And so that's where we left it. Ms. Taylor did say, well, able the following Friday, Thursday or Friday, to talk with Judge. And to my mind, well, that's too little, too late. As far as we know, these surveys are going on again right now. Wrapping up or starting somewhere else, whatever. It needed to be addressed quickly, not wait a week to have a conversation and then go into a conversation where you're left cold. We walk in the door and we aren't able to provide you the basis for our concerns. So you are completely helpless with information. That's not how it works. That's not how informed decisions are made. So
and yet nobody's out there talking about the fact that none of these citizens called the police. They called the prosecutor to say, hey, we got a survey. And then the prosecutor contacted the police, specifically Payne, to start investigating. And you wouldn't think just to ask Ann Taylor if you guys were expecting a survey to be done, like y'all said, then you wouldn't ask Ann Taylor if she's conducting a survey. Ding, ding, ding. Like, that's exactly what you would do if you were expecting a survey to be done. So why would anybody be in fucking shock here? Y'all are lying.
Prepared a motion. We made the attachments. We filed it mid-afternoon, early mid-afternoon, not late in the day as it's characterized here. And I appreciate that Your Honor didn't see it till later in the day.
Right.
But that wasn't the intent. The intent was to get it filed as quickly as we could. There was no scheme to do some, 5 minutes to 5 o'clock filing and take some advantage of the defense. That's not the way we do business. That's not the way I do business. And frankly, it's a little offensive to have that suggestion made, but I'm going to move beyond that. I have to say, I am disappointed to learn today that Dr. Edelman and his associates were not made privy to the non-dissemination order. But we can't undo that.
Why would they need to be privy to the non-dissemination order if Ann Taylor isn't giving them or providing them with anything? It's a protective order. Here, this is protected material. You can't use this, or you can't disseminate this. What in the fuck right here? Bill Thompson, you've clearly walked off the deep end right there. And then the judge not saying right here, well, Ann Taylor wouldn't have to give them, did not have to notify them of the non-dissemination order because they're not disseminating anything. Ann Taylor didn't disseminate anything to them. If I'm hiring you to do a job and I don't provide you with anything, why in the world would I be letting you know that, hey, like, we're in a gag order so you can't tell anybody the stuff that you're finding in your survey? I don't understand. This hearing should have never been live. This should have been closed off to the public because this in itself tainted the jury pool.
And once again, that's not of the state's making. My knowledge, everybody that has been asked to take actions of any type on behalf of the state has been made aware of those restrictions because they are our agents. And we know we are responsible under the court's order for the actions of our agents. Regardless, I'm disappointed. I also want to be clear that I'm not standing here today making a Bar Association ethical complaint against any member of the defense team. Yes, language in the non-dissemination order contains language that parrots the Idaho rules of professional conduct, but the
Bill Thompson wants everybody to know that he is not, I repeat, not making any Bar Association claims, any violations.
laundry list of things that the court lists, I think, are much more specific. And that's what we're concerned about. And if I'm wrong and those are in the comments, well, then maybe there's a violation of that rule, but that's not my interest. I have no interest in doing that. My interest is in taking care of this case, making sure that we can have a fair trial, making sure that Your Honor's non-dissemination order is honored. And at this point, trying to figure out a way to cure what has happened. First thing to do is we have to say, Your Honor, court needs to say, no, you will not ask any more questions of prospective jurors without the court approving it. Because we've seen that people retained by the defense cannot be trusted in that regard. Fools once, shame on you. Fools twice, shame on us. We don't want to get into that. They wish to proceed with surveys, they can, but they need to start over.
Start over in Lake County.
Yes, sir. Absolutely. Absolutely. There's no other way to get a fair comparison with any other prospective veneer without doing a new survey in Lake County and not including any of the people who were surveyed in this 400-person group. That's the only way we can avoid this taint. Again.
All right, I want to tell you guys something here. So I printed off this first day of April 2024, all the days, okay, that let's see, right here. Are you guys aware of this huge gap? State's response to defense 11 supplemental request for discovery filed January 22nd, 2024. States respond to defendant's 12th supplemental request for discovery filed March 25th, 2024. What that means is January 22nd to March 25th, no discovery was turned over. Ann Taylor's on her 15th request here. So on March 25th, they just had filed, getting the 12th handled. But what the hell? I want to go back and check when Ann Taylor is filing these dates. Why between January 22nd and March 25th? I mean, no, not turning over any discovery for January, 2 months, 2 full months, no discovery was turned over. You understand that? Unbelievable. I'll be on later though. We'll pick it up there. We'll be talking about Steve and Christy's statements that they made last night. And I'll weigh in. But I just know that during a 2-month period, and then before the January 22nd, 2024, November 20th, 2023. So again, 2 months. It's just wild. It's wild. Ain't no way to avoid the taint. It's tainted. Everything's tainted. January through March is when Batani was conducting his work. And we're talking about 2024. 2024. So I don't know. I'm going to pull up to see what documents. I'm going to print those off to take a look at everything as a whole. But I'm just saying there was a hearing where they were talking about discovery. And this is when Bill Thompson was like, I have everything put together. We can have everything to them by, August and da-da-da. Well, July 2023, July, August. Yeah, this is sad. March 29th, May 12th. Yeah. So we'll be back though. Join me then. But yeah, you would just think that they would be pumping lots of, information and oh boy, a lot of useful things. And I'll look into what the university charged after the what? Yeah, I'm going to print the rest of that stuff. But join me tonight. Tonight's going to be explosive. Tonight I got some never heard or seen shit. Okay? All right, guys, take care. Thank you guys, moderators. You guys rock. Thank you for those who became a new member there. Be kind to one another, and I will see you on the flip side.